Hi everyone, my name is Ashlyn Storms.
And I'm Sarah Salazar.
And my name is Richard Rodriguez.
The case we have chosen to examine is Stone versus Graham. The plaintiff, Sidell Stone, a parent of children who attend public school in Kentucky, is bringing the defendant, James Graham, the superintendent of Kentucky Public Schools, to court. The parents of the children attending these schools, led by Stone, were concerned about a statute that had been put into effect on June 17, 1978. This statute stated that all public schools must provide a copy of the Ten Commandments on the wall of each classroom. It said that these copies were to be purchased through voluntary private contributions. While these parents were not having to pay for these postings of the commandments, they felt as though it was unconstitutional for them to be required in every classroom. The parents believed having a posting required in each room from a religious text was violating the Establishment Clause of the First Amendment. The argument they took to court was that these postings of the commandments were pushing a religion on the students, and that the purpose was no part secular and completely religious. This case was taken to the trial court, where it was determined that the statute was in fact constitutional. The argument for this determination was that even though the Ten Commandments are from a religious text, the purpose was completely secular, and the statute did not advance or push religion on any of the students. It was argued that the Ten Commandments are historical, and that they are a good set of moral rules to live by. It was also argued that it was not a violation of the Establishment Clause, because the commandments were not being read or taught, they were only posted on the wall. Upon further examination from the Supreme Court of Kentucky, a different result was reached on November 17, 1980.
So there is one main legal issue with this case, and that is because it violated the Establishment Clause. And the Establishment Clause is found in the First Amendment of the Constitution, and it states that Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peacefully to assemble, and to petition the government for a redress of grievances. So essentially, this means that the government cannot favor any one specific religion or establish any official religion, which is what the term separation of church and state refers to. So this clause is in existence because it helps to ensure that the government isn't too biased in favor of one religion over another. So the Kentucky statute regarding the schools also required that a notation on every display of the Ten Commandments be written, and the notation stated that the secular application of the Ten Commandments is clearly seen in its adoption as the fundamental legal code of Western civilization and as the common law of the United States. The court said that the Ten Commandments were not prohibited to secular laws, but also focused on honoring God, which was establishing a specific religion in the classroom. The court stated that the Ten Commandments are undeniably a sacred text in the Jewish and Christian faiths, and no legislative recitation of a supposed secular purpose can blind us to that fact. The commandments do not confine themselves to arguably secular matters, such as the Ten Commandments. Such as honoring one's parents, killing or murder, adultery, stealing, false witness, and covetousness. Rather, the first part of the commandments concerns that the religious duties of believers, worshiping the Lord God alone, avoiding idolatry, not using the Lord's name in vain, and observing the Sabbath day. The court also stated that this is not a case in which the Ten Commandments are being integrated into the school curriculum, where the Bible may constitutionally be used in an appropriate study of history, civilization, ethics, comparative religion, or the like. In order to determine if the Establishment Clause was in fact violated, the courts used a prior case, Lemon versus Kurtzman, in order to come to that conclusion.
The Supreme Court ruled a 5-4 that that the Kentucky law was unconstitutional. The law said that public schools had to post the Ten Commandments in classroom. The court said this was against the First Amendment, which says that the government cannot support or promote any religion. To help make this decision, the court used something called the Lemon Test from a case back in 1971. The test helps the court decide if the law involving religion is okay under the Constitution. The test had three parts. First, the law must have a non-religious reason. Second, it cannot support or hurt any religion. Third, it should not get the government too involved in religion. The court said that the main reason for the posting the Ten Commandments was religious, which means that the law failed the first part of the test. Because the law did not have a clear non-religious reason, it was ruled unconstitutional. Some people say that the Ten Commandments are a part of history, so posting them wasn't about religion. They believe it could be allowed if it was help teaching history, but the court disagreed and it said that since the commandments are clearly religious, the law was not okay under the Constitution. And we agreed with the court decision because public schools should not promote a specific religion, and posting the Ten Commandments in classroom is somewhat clearly religious. Which goes against the First Amendment, which says that the government must stay neutral about religion. And in school, students come from many different backgrounds and beliefs, and when a school promotes one religion, it can possibly make another student feel left out or uncomfortable. So everyone should feel welcome at school no matter what they believe, and the government's job is to protect freedom of religion, not to push it. That's why we believe the court made the right choice, keeping religion separate from public schools, which helps all students be treated fairly.
So we chose an additional case to compare with Stone versus Graham. And the case that we chose is McCreary County versus ACLU of Kentucky. And this case was from 2005. So some of the important facts of this case were that the American Civil Liberties Union, which is a civil rights activist group that is dedicated to helping protect the rights of American citizens all across the country, sued McCreary County in Alabama after they saw that two Kentucky counties had posted a display of the Ten Commandments in their courthouses. So the American Civil Liberties Union sued the two counties in Alabama because they claimed that those courthouses had breached the Establishment Clause and that they were favoring one religion over another by posting those religious commandments in their courthouses. But the counties tried to defend their position and their stance of posting the Ten Commandments in their courthouses by modifying their displays. So they modified it one time in order to include other writings from US history and like the Declaration of Independence. And then they also modified it a second time to include some writings, additional writings, including the Star Spangled Banner. And one of their reasonings behind that was in order to try to convince the court that the Ten Commandments were highly influential to the creation of those documents, and tried to say that the Ten Commandments did have a secular purpose within American history. The court once again used the Lemon test from Lemon versus Kurtzman, and they found that the display of the Ten Commandments, even though that the courthouses claimed they had secular purpose, were still religious in nature. And to make some comparisons between the two cases, Stone versus Graham and McCreary County versus ACLU both revolved around the subject of a posting of the Ten Commandments, and both had a display. And there was both a violation of the Establishment Clause because both the schools and the courthouses were trying to push a religious message through a display of the Ten Commandments and try to pass it off as it having a secular influence in the history of America. But some differences were that Stone versus Graham was in a school setting, McCreary versus ACLU was in a courthouse setting, and Stone versus Graham didn't attempt to modify their display. They just had one display of the Ten Commandments with a notation underneath it in order to try to prove their point. But McCreary County versus ACLU modified their display not once, but twice in order to try to create a connection with US history and to try to validate their reasoning for posting the Ten Commandments. But ultimately, Both cases were found to have violated the Establishment Clause, and they were both found to be unconstitutional under the law. And that is the end of our presentation.